Hey, everybody. Welcome to the IR Digital Podcast. It's a part of the IR Global, which is the largest international professional services network. I'm your host of the podcast, Jennifer Riggins. Today, we're sitting down with Tenny Amin, owner and managing partner at TALG or TALG Limited, who specializes in family law. Today, we're talking about not the happiest of topics, but I definitely think an important one. It's about parental alienation. Penny, if you can please introduce yourself and talk about your own journey to family law and just help us ground it in your expertise. Thank you.
Of course. I have been a practicing family law attorney in California since 2003. So I've been at this for 22 years, and I exclusively practice in the field of family law. I'm a litigator and a mediator. And I originally actually started working in the corporate world. I worked in a law firm that specialized in corporate, transactional, and litigation. And that's what I was doing. And I had no desire whatsoever to go into family law. And one of the partners asked me as a first-year student if I could grab my briefcase, put on a suit, and run into court for her best friend who had a family law hearing for custody of her child. And her lawyer had bailed that morning. And me not wanting to disappoint the partner, clearly said, I'm on it, don't worry about it. And so when I got there, I was thrust into this completely unfamiliar setting in this unfamiliar world. And I remember being so nervous, just waiting our turn to go up and reassuring the client that I got this, don't worry. And we actually did really well at that hearing, and it kind of sparked something in me. I decided, no, this is what I want to do. And then Ismail and we started our own law firm 20 years ago, and I moved into the family law practice, and I've been at it since then.
And I guess it's a different situation where often it's not like a lot of the law that there is a lot of gray area. There isn't necessarily a right or wrong in family law. There's a lot of gray area. There are often children involved and hearts broken. And it's obviously a very important topic, but also, I would assume, a very difficult one at times and emotionally draining. But for those that are listening, I always like to ground it in who do you think would benefit from listening to this conversation today?
I think anyone going through a divorce, particularly people that are going through custody and visitation issues, parental alienation is incredibly prevalent. And it's something that ideologically has two very separate camps in the family law world, which I'll go into. And so I think that people are incredibly passionate about it one way or the other, whether they believe it actually exists or whether they believe it doesn't exist. They are passionate about it. And there are judges who actually sway specifically one way or the other. So I think if you're in a situation in a custody battle and you feel that you are being alienated by the other parent, or perhaps you're being accused of alienation and you don't believe that you've done it, then this might shed some light, if anything, to let you know that you're not alone and that this is something that I encounter in my cases every single day.
Mm-hmm. So, what exactly is parental alienation? Because often divorces aren't the most amicable situations. Is there a legal definition, or what is or is not parental alienation?
So parental alienation is behavior by one parent that essentially undermines or interferes with the child's relationship with the other parent. Okay. And this could be anything. This could be speaking negatively about the other parent. It can be coaching your kid to express negative feelings about the other parent. It can be oftentimes interfering or blocking visitation or communication. It rises to the level of falsely accusing the other parent of abuse or neglect, or encouraging that child to have fear or guilt that something had happened to them, whether it's true or it's not. So all those behaviors fall under the umbrella of parental alienation, but it essentially is one parent undermining the relationship of the child with the other parent.
I imagine this happens all the time, and I've experienced in my own life in ways, but how is this a legal line to draw? Because some of those seem, if you have legal custody access and someone's blocking you, that feels more of a very clear legal issue versus talking negatively, or I assume if someone is actively doing this and engaging in encouraging a child, they could just be like, that's the child, especially if it's
Mhm,
like a teenage child or a
mhm.
preteen. Be like, oh, they're just a teenager, but like this seems very intangible and hard to prove, besides when you're talking about you were supposed to have custody on this day and you did not. So is there a
100%,
law?
you nailed it. Yeah, and that's exactly what we as family law lawyers struggle with. I've had cases where it's very clear, where you have a parent saying, you didn't pay me child support, I'm not going to bring the child over for visitation. And those are two totally different things, you know? Or you're saying you're not allowed to attend the parent-teacher conference, or I know it's your time to have FaceTime with your child, but I'm just going to turn my phone off. Those are all parental alienation. And if I were to go into court with that sort of evidence, then 100% I could show that this is an alienating parent and you could lose custody. Courts punish that very severely,
Oh,
because
okay.
the whole concept in family law and with family law lawyers is we believe that in some cases divorce is inevitable, right? Half of marriages, more than half of marriages end in divorce, and most of the time it's contentious. Who you marry is not who you divorce. So, and children are often in the middle of this. And so there will be there's a belief that children will survive and actually thrive, and that you don't have to be worried if you're someone going through divorce, I'm ruining my kids. They will actually be fine. Children are far more resilient than we give them credit for, but they have to have frequent and continuing contact with both parents. That's the key. They have to feel like their house life has not changed and that they're seeing both parents at the same rate that they were during the marriage. So if you are blocking a parent from having that communication and having that contact, and you're engaging in alienation, your punishment will be you will lose custody.
Okay.
So that doesn't mean automatically, because there are various degrees, but if you're given an opportunity to correct your behavior and you don't, then you could very well lose custody of your children.
Does it ever backfire, usually for women that are subject to an abuse in marriage, and then they reasonably feel scared for their children being in custody, but the law says they have to give custody? Could that backfire against them? Or
Oh,
there's a lot of like financial abuse mixed up in this, and emotional abuse and physical abuse that can happen?
100%. There's a lot of situations where you have women who have suffered abuse at the hands of their partner, and they might have a domestic violence restraining order against that person. And it's very difficult to allow your child to visit with someone who is a known abuser.
Yeah.
And that is one of the reasons why the people on the other side of the camp have always said that you have to believe a child when they tell you that they don't want to see that parent because they are scared of them, or because they've seen that parent engage in abusive actions against the other parent. So we have a whole 50%, I would say, of the family law lawyers and the people in the family law court system believe that when we say a child has been alienated, we are essentially undermining that child's autonomous belief that they've come to on themselves, that this is not a good person. I've seen this person abuse mom. I will not go see this person. And when we force that child into a situation where they have to see that parent, we are doing them a disservice. We're putting them in a very abusive environment because we don't believe what they're saying.
Mm-hmm.
Now, the other side of the camp will say, they're being fed lies. I didn't do anything. You know, this person has fed lies to my child, and now this child is scared of me. I haven't done anything. And that in and of itself is another belief, but that's kind of losing ground, to be perfectly honest with you. We're giving children a lot more say in believing them sometimes over the parent who's claiming alienation.
Okay. agree with that choice. I
Yeah.
guess that maybe from like 6 or 7, they have more of an ability to speak more freely, but that I think I do believe in children's rights. But does the law, where is the law right now? And I guess, do you practice exclusively in California, or where's your jurisdiction to give context? Or
I practice exclusively in California. And with regard to the law, like I said, California tends to be a lot more progressive than the other states. And by that, what I mean is parental alienation syndrome, just as a behavioral disorder, is not recognized in the DSM, meaning that it's not recognized as an actual behavioral disorder. And what that has essentially done is that because it's not an official diagnosis in the DSM-5, most legal discussion centers around protecting the child and believing what they are saying about the other parent. That has been my experience with California courts recently, is that when a child says, I do not want to see this person, courts will not force them to do it. And I think honestly, the reason for that has been we've had some pretty notorious cases where the child has been forced to go see that parent and they've ended up dead or they've ended up abused. And then you have the other parent saying, I told you to listen to my child. So we put a lot of emphasis now in California on the child and what they are saying, more than I would say other states do, for sure.
and DMS, I always like to clarify an acronym. What is this?
That is the official manual of diagnostic behaviors. It is what we use in the family law world when we are referring to mental health disorders. And there was a strong push to have parental alienation syndrome, PAS, recognized as an official diagnosis. So you would take your child and you would say, look, this child's been diagnosed as having PAS. This child doesn't hate their dad because the dad's really a bad guy. They actually suffer from PAS because mom filled their head, and that was not recognized as a diagnosis. So what that tells you is we are believing children and we are believing that they're making independent judgments more so that they are being fed lies and then turning around and alienating the other parent. And if you're a parent, you go one of both ways, right? Everyone feels differently about it. Some people will say, I can't convince my child to hate her dad. I can't do it. If her dad's really a good guy, there's nothing I could say that would make my child hate him. And then there's other people that can say, oh, yes, you can. Oh, yes, you most certainly can. But I'll be honest with you, without taking sides on any given case, my experience has been is it's very difficult to alienate a child completely from the other parent unless prior to the divorce, there was some animosity there between that child and the parent to begin with. It didn't start off as a lovey-dovey relationship and then devolve into parental alienation. It might have been some tension there to begin with, and perhaps that tension is fed by the other parent who manipulates and knows they already don't like that parent. And if I say this and this and this, but I've rarely seen a case where I have a client who says, we had the best relationship in the world and now my child hates me and it's all because of her.
So we are a network at IR Global. That's how we met, of other lawyers, et cetera, and well, not et cetera, financial advisors and such. But people move across state lines, and that becomes, is that a federal case then because it's between two states? How does it conflict with other states that maybe don't have any laws about this or don't have, as you alluded to towards the beginning, some judges have strong opinions either way on this. So how does it work when you're working with other states or even with international? I don't know if that happens.
Yeah, no. Well, in family law, in order to fall under the jurisdiction of, for instance, the California court, you have to be domiciled in California for a continuous period of 6 months.
Okay.
So you have to have been living in California for 6 months, and that means you have to have a California driver's license, a bank account, renting, buying something, a job. You have to demonstrate that I have actively been here. If you were to move to another state, then you would only fall under the jurisdiction of that state if you also lived there for 6 months. The child lived there for 6 months. So we don't allow forum shopping, in other words.
Okay.
You don't get to say the child support laws are better there. I can get more alimony over here. Or they believe in parental alienation more than California, so I'm just going to move my kid there. It actually have to get permission from the court in order to move. That's number one. You can't just move with your child in the middle of a divorce. And if you're given that permission and you establish residency for 6 months, well, now you're no longer a California resident, you're a Nevada resident, and you can go to court in Nevada. So we've made it difficult because you're honing in on something. People do like to forum shop in family law a lot because states differ a lot, right? And so I have a lot of people that will say California is way too liberal with regard to these principles. I want to move to, Nevada. Not that easy. It's not
But
that.
then what if the other parent, so is it the domicile of the kid?
Yes.
So the other parent's another state, it's still California law then because
The child is there.
Yeah, the child, where the child is present to school, for example.
Yeah. So you could be a parent who you have visitation, let's say. So you're living in Nevada and mom and the child are living in California. So you see the child probably on summer breaks, winter breaks, maybe a weekend here and there, right? Because you're in a different state. If there is ever an issue, you're traveling to California to appear in a California court under California laws because that's where your child lives.
And this is something I assume we've been talking a lot about in divorce law, but I assume the potential for parental alienation could continue throughout a child's life post the divorce as well.
Oh, for sure. It does. It really truly does. I mean, it's once that child has convinced themselves that they do not want to have anything to do with this parent, regardless of what the reason is, right? It's very hard to undo that. And one thing that's interesting is that I wanted to touch on is we used to send those kids to reunification camps. That was our, I see you, I know.
It just sounds very similar to re-education camps that like millions of
100%
told they're not gay, which is crazy.
Years and years ago, I would say probably like 10 years ago in my practice, these camps were everywhere. And I would see it all the time. And they were reunification camps. And if your child was alienated from you, we would force that child to go to this camp with the alienated parent. And essentially, we would force them to be in a situation where they were only with that alienated parent and these psychologists who are essentially going to sit the child down and convince them that this is a good person, you've been alienated, you've been brainwashed, we are now going to unbrainwash you. And this was standard. This is what we were always doing.
And I assume this is not publicly funded. This is a private business.
Oh, 100%. Yes.
Sure.
These were private camps. They were led by psychiatrists and psychologists who believed in reunification therapy, is what we used to call it. And they were mostly outpatient therapy. And I mean, people had differing views about them. We would see videos of kids crying and screaming, being dragged into a car to go off to reunification camp because they're genuinely terrified of this parent. Some kids would come out and say, yeah, I was brainwashed and, now I see clearly. And other kids would be devastated. They would never recover from that camp. It would have long lasting effects on them. But in California, we now have a law called Piqui's law. It's named after a child who was actually murdered by their father in California as a result of something like this, where the mom pled with the court to not allow the child to have visitation with the father. And the judge, unfortunately, and I know this judge, he's come under a lot of fire since then, sided with the father and said, you're alienating the child. I do not believe you. And he ended up killing the child. So as a result of Piqui's law, we don't do that anymore. You cannot ask a judge to send your child to a reunification camp. You can't. So that's gone out the window, which, there's a lot of evidence to support that. So,
Of course. So if a child is listening to this, a teenager, like I don't know, don't in any way claim that this is for little kids, but also maybe I don't see anything that's, a parent's choice. What would they do in this situation? How can they gain onus and stand up for themselves? Because there is a
Mhm.
financial aspect. Lawyers are not free, famously.
Mhm.
Um, what could a child do? What are their recourses, at least in California, when something like they feel unsafe with a parent, whether it's because of divorce or not?
Mhm. Well, we have a really good system in California where we allow children like that to have access to their own counsel.
Mm,
And that counsel is called minors counsel. And the child or the parent would petition the judge, appoint me minors counsel, so that I have someone speaking on behalf of myself. Mom has a lawyer, dad has a lawyer, I'm being drowned out here. And minors counsel, I've taken on minors counsel cases. You get appointed by the court to represent the child, and that's your opportunity to have that discussion with your client, who might be 7, who might be 8, and they confide in you, because it's a lawyer-client privilege, about how they really feel and what they want to communicate to a judge and what they want to tell the judge. And that would then be my responsibility to convey their feelings to the judge. And I can probably do it in a more articulate way than a 7-year-old would, you know? And so we give the children a voice through a lawyer who's appointed specifically for them. And I love that. I love that they have that opportunity to speak, because a lot of children, they're not going to go to court, and they're not going to speak to a judge who they are scared of, and they're not going to voice their opinion. And sometimes in my cases with minors counsel, I've gotten a very differing point of view when I've had the child away from the parent they're living with.
mhm.
When that child has come to my office, all of a sudden they are not saying the same things they were saying when they were sitting on the couch and mom was sitting next to them, so it helps to kind of create that distance and give them that opportunity.
That's wonderful. It's important to give them voices. Is there anything I should be asking you about because of everything intermingling in the US these days under the ICE raids, etc.?
Mhm.
How does immigration law and undocumented immigrants, do they have access? Do these children, undocumented children in California, have access to these services and rights?
We don't differentiate on immigration status when it comes to the family law court. It's not something that is ever asked. It's not something that I ever inquire of my clients. It's not something that is even relevant, to be honest. You're in California, you're getting a divorce, and you're entitled to be in front of the same judge in the same courts as anyone else, And I'm sure there have been cases where I have represented someone who was undocumented, but that was so irrelevant in the realm of what I do that I haven't even brought that up, and it hasn't been an issue. Now, of course, when you have someone who has a visa who is contingent on the other person and they're getting divorced, then that becomes an issue, and they tell me, what's going to happen to my spouse? Are they now going to be deported because they're only here because of me? And I will loop in an immigration attorney to help. But in terms of one parent is undocumented or not, it hasn't been something that I've dealt with, and it hasn't been something that the judge has had an opinion on one way or the other. We're there for the best interests of the children. Essentially everyone in the family law court wants to protect these kids. We truly do. So whether that child was born here, born somewhere else, parents came here legally, but we're protecting the kids. We don't care about all that extraneous stuff.
That's wonderful. If people want to get in touch with you, what's the best way? Anybody? Yeah.
Well, my law firm is TALG, and our website is talglaw.com, TALGLAW.com, and all my information is on there. And I have an open door policy. I will listen to anyone I will take a consultation with anyone. And sometimes people will pay for a consultation simply because they just want to be heard for an hour, you know, and maybe just have someone tell them that their concerns are legitimate, and that's it, you know? So yeah, contact me at talglaw.com. My phone number, email, all my information is on there.
Okay, thank you so much, Tenny, and thank you, listeners. This episode is probably relevant to someone you know. I certainly think it is to some people I've known through different friends in different stages of their lives. So please do feel free to share this. I think it's an important one. I think we had a really important discussion today. So thank you.
Absolutely.
And
Thank you for having me on here. Thank you.